final matter to come before the court this morning is Sandra Althof et al. Versus Hudson City School District. Both sides will have 15 minutes to present oral argument. If you're the appellant and wish to reserve any time, you may reserve up to 5 minutes. If you let me know when you get started, I'm keeping the clock. You can also reference it on the wall. The arguments are being recorded and will be posted on the court's YouTube channel. So please stay behind the podium, keep your voices up, don't use names of any children, minors, or victims. You can refer to any relevant such person, although I'm not sure you will need to in this particular case by initial or by any nondescript term. The judges have read your briefs. We're ready to proceed when you are.
Thank you, Your Honor.
Good morning. Would you like to reserve any time for rebuttal?
Yes, I would like to reserve 5 minutes for rebuttal, please.
Certainly.
May it please the court, I'm Warner Mendenhall, and with me is Frank Lucas, a recent graduate from the University of Akron Law School. I represent plaintiffs Sandy Althof, Arbella File, and George Carson. And we had 4 categories of violations that we saw. One was the violation of 379204, which was the prohibition on discrimination regarding the emergency use of vaccines. The second area was the lack of authority, because we think it conflicts with recent changes that the Ohio legislature made in terms of clarifying what the health department powers were. Thirdly, it violates constitutional rights, Article 1, Section 1, because there was a forced use of a medical device. And finally, we alleged coercion because officials had used their position to coerce behavior that was in violation of the constitutional rights. This, going back in time, this was actually not an emergency. The governor had pulled down the emergency prior to the state legislature passing some laws limiting his emergency powers. The state legislature clearly stated that it wanted to get control of those emergency powers and limited emergency powers to a 90-day period. And yet, the school district went ahead with implementing policies that we feel were violative of these constitutional rights. Now, the first issue, obviously, is that this case was dismissed under 12b-6. And the issue there is whether or not it is beyond doubt that there's a controversy or justiciable issue. And we do think there is a remaining justiciable issue, because if you look at what we're arguing about the power of the school board. So the school board has never disavowed its power to implement these mandates, its power to quarantine students and take control of their of these health issues. And this is a power that, so the case is really about the power, and that power, until it's disavowed and disclaimed, is still at issue, and that's what's at issue in this court case. Not whether or not, for a minute they implement these mask mandates. And if you look at Exhibit 2 on our complaint, they actually say that if there is a finding by the health department of a concentration of COVID, that they have the power to re-implement it. So we think that's, we think it is still a justiciable controversy. The other thing that the court really dismissed this on mootness. And mootness has really had a lot of attention recently, particularly with West Virginia versus EPA. And the burden shifts on mootness. It's not our burden to show something's not moot. It's the state's burden to show that it's not moot, or the school district's burden. And that is considered to be a formidable burden. Under citing to Friends of the Earth, it's a formidable burden showing that it's absolutely clear the wrongful behavior could not reasonably be expected to recur. And Friends of the Earth is interesting because it really does parallel what happened in Hudson, because the wastewater facility had a permit. Now, it shut down the wastewater facility, but the permit was still in existence. So that wastewater company had the power still, despite having completely shut down the facility and ended the behavior that was complained about in Friends of the Earth. So we think think that parallels neatly to this. And then West Virginia versus EPA cited the Friends of the Earth and said, voluntary cessation does not move the case unless it's absolutely clear it's not going to happen again. So the question right now is, has Hudson made it absolutely clear? The answer is Exhibit 2, no. It said if there's a cluster outbreak, it can implement the policy again. So I think to focus on implementation of a power without and ignoring the power like the lower court did is where the problem is. And that's what we're appealing.
Council, has the Ohio Supreme Court adopted the mootness standard articulated in West Virginia v. EPA?
The Ohio Supreme Court, I don't think that it is specifically considered that decision out of the U.S. Supreme Court yet, as far as I know. But we think that that is what the standard should be, and obviously we think it's an issue in this case. Now, even if this were moot, even if that is the framework of this, we still believe that this is capable of repetition and debating review. And we also think it's of great general interest, and we cited to Huffer versus Circleville High School that the issue of the authority of local school boards to make rules and regulations is of great general interest. So I want to move on a little bit to the statutory powers, because the statutory powers and the system that's been set up, I think, is actually clear, though it does need to be read in order. First of all, under RC 10742, we're no longer in a state of emergency. That was lifted in June of 2021. And then the state Senate limited the Board of Health power to only have power to quarantine and isolate for those who are diagnosed or in direct contact with those who are diagnosed with the disease. So that power to isolate and to quarantine was vested in departments of health and local health departments, not in school boards. Now, the school board has the duty to cooperate with the Department of Health if there is a finding by the Department of Health that somebody has a disease or has been in contact with somebody who has a disease. The other power that the school board has, of course, is explicitly in Ohio law. It's revised code 331371. It can exclude any pupil or employee who is ill with an obvious illness, but they cannot exclude asymptomatic people without a Board of Health or Ohio Department of Health ruling. The other issue beyond that's statutory but at the federal level, is this issue of masks. Many of the courts have said these masks are not medical equipment, medical devices, they're not medical. I think that is absolutely and simply wrong. If they're not medical, if they're not to constrain a disease or stop transmission of disease, then, and they're not medical, then there's no point to any mask mandate right off the bat.
Is the issue whether they're a medical device, or is the issue whether it constitutes medical treatment?
Well, I'm going to blend the two. I think it's a medical device that treats the person by limiting respiration. And there's some authority for that with the FDA. The FDA actually gave masks, including cloth masks, including these paper masks, an emergency use designation. But part of emergency use designations, this is 21 U.S.C. 360 BBB-3, part of it is that they're supposed to tell you what the risks and benefits are, known and unknown risks and benefits, or whether risks are unknown. And you're supposed to have under emergency use authorization the option to refuse to use an emergency authorized medical device. The FDA also called it a medical device. And it required a label saying that it did not provide protection for against viruses or reduce infection. That's on all of the mask labels. So I think the courts, and we've argued this case a number of places in the state of Ohio, to say this is not medical if you accept that, then it's nonsense. If you accept it as medical, then we have these protections. And that leads then to Steele versus Hamilton County and our right under Ohio's constitutional Article 1, Section 1, that unless someone is of immediate danger to theirself or others, and there's no less intrusive means, that's the only time that medical treatment is appropriate without consent. And the school district has the burden of proof to prove these elements. So we think that that has caused essentially an unconstitutional condition that, hey, you have to have a mask to come to school. If you're not vaccinated, you have to quarantine for 5 days.
Council, is the school district's policy on masking, did they change it to making it optional?
They did, yes. But they didn't disclaim the power to reimpose a non-optional mask policy.
Okay, so bringing that back to the question of movements, right? So how is it more than a theoretical possibility that that could happen? How do we know what the legislature will do or what the law would be should that ever happen?
Well, and this is where I'm trying to get at a little different level of generality. I want to focus on the power that the school district claimed to have that I believe it does not have, and that remains a controversy between the school district and my clients. We're contending they simply didn't have that power and don't have that power, and the court needs to make it clear. We've had governments throughout.
How is that not an advisory opinion, though, that you're asking the court for?
It's not advisory because we're not saying a hypothetical that they have this power. It's not a hypothetical. They claim to have this power.
And how do we know, though, that the legislature or something, that the context of what would happen should this ever be changed to the policy which you object to?
You mean if they go back to masking? Well, I think we need to make sure that they never do that again.
So that would be advisory, that would be preemptory, right?
It would be a decision that would declare that they don't have that power. That way the school.
Under the current law?
Under the current law.
Under the law, okay.
Yes.
But wouldn't it be theoretical to the extent that because that is not the policy, they changed it to optional, they changed the policy, they discontinued the policy to which you objected, or at least those provisions to which you objected, and there could be, and it hasn't to date been reinstituted. We don't know if it'll ever be reinstituted, right?
I'm going to make it use a real simple analogy.
Okay.
There's a switch on that wall that they claim they can turn on and off. I'm saying that switch shouldn't be on that wall at all. They can't turn it on and off. That's really what it is. That the policy is that they can implement masking or quarantining or any range of other things, and the reality is that policy is illegal under the state constitution.
And council, I need to let you know you have about 3 minutes left, so you can continue. And I want to make sure that if there was there.
That's great, I think.
I'd like to reserve that for rebuttal anyway. Thank you very much.
Thank you, Your Honor. May it please the court, Colin Jennings on behalf of the Hudson City School District Board of Education. I think the issue before this court very simply is whether or not this case is moot. I think that the trial court properly reviewed the facts, understood that the masking mandate that is the challenge of the lawsuit that was filed was actually withdrawn. It was withdrawn 18 days after the original complaint in this matter was filed, and it was withdrawn because the guidance from the public health officials in the state of Ohio changed. It had nothing to do with the filing of the lawsuit, so in terms of voluntary cessation relate to avoid judicial review, that didn't happen here. It was clear it was a result of changing guidance from the public health authorities. I think one of the core issues, candidly, is the standard of review. The question before the court is whether or not this matter is justiciable or not. The trial court took a look at the issue, decided it was not. Our position, based upon the Mid-American and App.No cases, is that because the court dealt with the justiciability and not the merits, that this should be reviewed based on the abuse of discretion standard.
Counsel, let me just go to that issue directly, because one of the arguments by the appellant here is non-justiciable. That is a hard word.
It is hard.
But instead, that found that it was moot, and that this is a declaratory judgment action. Isn't there a difference between the two?
No, I think justiciability goes to, there are 4 tenets of justiciability. One of those is mootness, rightness, standing, political question, and mootness. Those are the 4 categories that rise to the level of justiciability, and whether or not there's an actual controversy before the court for resolution. The court took a look at it, said there is no live dispute, no live controversy between the parties. There is a mere possibility that a public health organization could declare a cluster, and then they may bring it back based upon the guidance that was in place at the time. That hasn't happened for almost a year and a half.
Oh, let me
I'm
stop
sorry.
you there, because we all have such limited time, and everybody wants more time. If the board acknowledges that it still has the power to reinstitute if there's a cluster of COVID cases, how is the matter moot?
The matter is moot because, first of all, that controversy is just a mere possibility. That situation hasn't happened yet, and it hasn't happened for almost a year and a half since the masking or the mask play, or since the policy was withdrawn. That hasn't happened, and in the interim, President Biden has withdrawn the federal public health emergency, so the circumstances have markedly changed, and the question of what the school district may or may not do in a future circumstance will depend on the circumstances at that time, the guidance from the public health authorities, and the claims that were asserted were focused specifically on the COVID-19 response, not necessarily in future action. And so the claims that were asserted and the relief that's sought is very narrowly limited, and it's moot.
Okay, I understand all that, but I guess I'm still confused in regard to, is there a policy still in effect with the school board that if there's a cluster of COVID-19 cases, and the health department declares there's such a cluster that they can require the students wear masks again?
I think the board at that time would look at the guidance from the Board of Health and determine whether or not they want to follow it at that time.
So you're saying there's actually no policy in effect that if there's a cluster of COVID-19s, they can institute the masking of students again?
Correct. There's no formal policy. I think the school's position is they would have the discretion to cooperate with the boards of education consistent with Ohio law, and then at that point, if that were to come, then I think this issue would become appropriate for judicial resolution at that point.
Okay, so you're saying if that were to happen, that the board, according to your analysis, would have to adopt a new policy?
Correct. There is currently no policy in place, but the policy said that consistent with the guidance from the public health authorities, they were withdrawing and going into optional masking, but in the event that a cluster outbreak was declared by the public health authorities, they would have the option or ability to reinstate it at that time, but there's no formal policy or dictate that would happen.
But from what you just said to me, it does sound like they're retaining power.
I think they're retaining the discretion to make a decision about at that time.
Right,
I
but
think-
you don't have discretion if you don't have power.
Correct, but there's a line of cases in Ohio that essentially says school boards have the right to act in furtherance of the health and safety of those within its buildings and facilities, and it has an obligation to cooperate with the public health authorities. And by doing so, looking at the guidance that's being provided, they will make an independent determination of how to exercise that discretion at that time, based upon the circumstances then. The passage of time and the change in the policy has rendered the current dispute moot.
Thank you.
The other issue is capable of repetition and evading review. I think that's just a subset of the voluntary cessation argument, and really because such a long passage of time, the COVID-19 pandemic is over, and the relief sought was very focused on COVID-19, that the circumstances here aren't capable of repetition. The issue of whether new guidance comes out and the exercise of discretion at that point, there may well be a live controversy, but until that time, there is no live controversy. And I think that the trial court did a good job of taking a look at these issues, being very methodical of going through just the mere possibility, and finding that really what was being asked for was an advisory opinion finally, the public, or great in general interest, that is a very rare and cautiously used exception to the mootness doctrine, and typically is reserved for the highest court in the state. And here, the issue may have been of great public interest at the time during a once-in-a-lifetime pandemic. Now, fast forwarding a year and a half after the formal end of the COVID-19 pandemic, the issues are no longer of great public interest. In fact, they're historical, that the circumstances have changed so much that the controversy that was the dispute set forth in the amended complaint isn't relevant anymore, it is therefore moot, and that's ultimately what the trial court, we submit, properly determined. And we would ask that the court affirm the district court's dismissal of the case based upon mootness. Thank you.
Thank you, Council. And I don't know if you have just under 3 minutes.
Thank you. You know, I've read that the statute that he's referring to regarding the safety and interest of the school members of communicable diseases is revised code 33.14.6.7. And I have read that over and over again to try to figure that out exactly. In what it appears to be, and is very clear, goes right to the title of the statute, that's a statute about immunization. That's what it's about. And then there's a follow-up to that, 33.13.6.7.1, which again focuses on immunization. And it also happens to recognize within that statute, 6.7.1 does, natural immunity, contraindications, religious convictions, and reasons of conscience to not take any of the mandated vaccinations that were mandated by the state legislature. But I think that's the important thing, is that 33.13.6.7 that they're relying on is about immunization. And it goes very well with the school's other power, which is if someone is symptomatic, they can send them home. That's also specific in state law. So boards of education have that management and control of education and control of their buildings to that extent. But when you go beyond that, when you're talking about quarantine and mandated medical masking, then you have to look to the Ohio Department of Health and our local departments of health for the power to impose those types of remedies. And again, and I appreciate Judge Carr's inquiry. We really are focusing on the power to do this. Even in what I heard today, the school district is not disclaiming the power to implement quarantining, isolation, and use of a medical device.
But counsel, isn't it possible that since the policy is not in effect, right? The one that that gave rise to this suit is not in effect. Would you agree with that?
I don't.
Okay, because you think it could be reinstated,
No,
so they're, okay.
no. I think the policy of the school board is that it has the power to do this.
Okay,
That's the
I understand, so
Yeah.
let me just take this a little bit further. But is it true though that the state legislature next week, given what you just said about what the health department can do versus what a school board has the authority to do, couldn't the state legislature next week say, oh, the school district has the authority to implement a mask mandate?
You know what, the state legislature could do that.
Okay,
And
and
in
then,
fact-
council, and then if they did that, wouldn't that change, wouldn't that change the arguments here? And so, since that is possible, doesn't it make this speculative?
No. The state legislature sets out what the powers are for our local school districts.
Sure.
And they can change that tomorrow if they choose to. Just like in 2021, they made it very clear that where the power for isolation and quarantine was with the health departments.
Okay.
In 2021, that summer, they changed the rules and made it crystal clear where that power lay, and that it was not in the schools. And in fact, it addressed some of the school power with the EUA. So I agree with you, the state legislature has a lot of power, and this goes right back to Jacobson versus Massachusetts. Our states have the power to shape the contours of our public health policies. And we've done that in Ohio through our, Article 1, Section 1, which gives us right to life, liberty, and happiness. We've done that, and the interpretation of that through the Steele versus Hamilton County case, which also says you can't mandate this unless someone's in, you cannot mandate a medical treatment unless someone's in imminent danger to themselves or the community. Thank you very much, Your Honor. Thank you.
Thank you both for your presentations today. The court will issue a decision in due course, which will be mailed to all parties to this appeal, as well as posted on the Supreme Court website. We are adjourned until Tuesday, May 30th.